Always choose.
We ask the questions.
What is needed in the world?
Predsjednik Međunarodnog krivičnog suda za bivšu Jugoslaviju Theodor Meron, nakon posjete Bosni i Hercegovini, posebno obilaska najveće do sada otkrivene masovne grobnice u toj zemlji, kaže kako mu je vrlo važna ova posjeta. U intervjuu se osvrće na kritike koje su upućene na njegov rad i posao Haškog suda, te o završetku procesa pred tom UN-ovom ad hoc institucijom.
Mr. Meron, thank you very much for being with us.
Thank you for coming here all the way.
When we speak about Tomašica and Prijedor region, you said there I'm facing the horror, and you explained it in your rather emotional speech. But what is going to change after this visit, or is it anything going to change in terms of prosecuting those who've committed the crimes?
As you know, the prosecutor in this tribunal, in all tribunals, at least those which are following our legal system, which we are applying here, is an independent person. Under our rules now, the prosecutor cannot present new indictments. But of course, that should be the role of the local courts in Bosnia-Herzegovina and elsewhere in the region. One of the things which is so very important and constructive was the reconstruction of concepts of and development of concepts of rule of law in former Yugoslavia. The fact that we now have at the level of the state court in Sarajevo a special chamber of war crimes. Nobody ever believed that despite criticism even on those courts, that so much will be done to prosecute people accused of war crimes before local courts. Let me tell you, we will always need a very strong synergy, coexistence, independence between international criminal courts and national criminal courts. International criminal courts are small, they are costly. Frequently they are far away from the place where crimes were committed. In order to reach the dimensions of those terrible events that occurred in the former Yugoslavia and elsewhere, you need to see prosecutions on the local level. And the fact is that following the stimulus, the trigger caused by given by this tribunal, by the notion that we showed that war crimes trials can be credible, we saw a considerable revival, renaissance almost, of national prosecutions, starting from Latin America and going all the way to Africa. So I think that we need that correlation. And you ask me what has changed? What has changed? Perhaps there will be a greater stimulus in the former Yugoslavia to proceed to preparing and continuing indictments and charges and procedures against those responsible for those terrible crimes.
So you expect that the local court in Bosnia and Herzegovina prosecute crimes in Prijedor and the region?
They do so already, but I think that perhaps more the events such as the discovery of the mass graves in Tomašica might give a greater stimulus to those crimes and might show all the ethnicities there that it is in the interest of the people of the area to try people who are accused of war crimes, to show that those trials can be just, and by so doing, by establishing the notion of justice and rule of law, pave the way for eventual reconciliation between the people.
This mass grave, Tomašica, was found after 20 years, more than 20 years. So what do you say about 20 years of silence? Local people failed somehow to deliver the information, but also the intelligence agencies also failed. So what do you say about them? What is your cooperation, or if there is any cooperation with intelligence agencies?
If there is such cooperation, this is a function again of the prosecutors. Judges do not have contacts with national administrations, nor and certain not with intelligence agencies. You know that. However, However, it's terribly distressing for a person like me to think that 20 years those things were not known, that those excavations did not happen right after the events. I spoke to someone who said his family, or a member of his family, was identified. Just put yourself in his situation. How great is his pain that he could not give his relatives a dignified burial. It's very sad that this was discovered. Let me put it this way, however. It's better that these graves were discovered now, that the remnants were excavated, that they can now expect a decent, dignified burial, then they would not have been discovered. So yes, disappointment at a long period of time, but yes, satisfaction that finally this is happening.
And about what about jobs of the prosecutors here at sorry, the ICTY? When we look back 20 years after, do you think that the work of prosecutor in many cases have been sufficient?
Well, look, it is not for judges.
But you're an expert in.
Well, I will answer your question. Not for the president of the tribunal to comment on the work of the prosecutors, but I am quite sure that all the prosecutors we have had here did their best to do a very good job, and they are doing a very good job. From the beginning, we had some great personalities here, really leading personalities, including, of course, Justice Goldstone from South Africa, Madame Arbor, Carla Del Ponte, Brammers. These are all very strong persons to whom we all owe a strong debt of gratitude for a very difficult job that they are doing.
But as a judge, when you look at the facts presented to you, do you feel sometimes this could have been better?
Look, as a judge and as a former president, a professor of international law, you always ask yourself, would you have done it exactly this way? But this is not my role. This is not something which is on my intellectual agenda. My professional agenda is to take the indictment as it comes from the prosecutor and proceed on that basis. Anything beyond that would be judicial engineering. The prosecutor or the public would not like judges to rewrite the case for the prosecutor, but I'm quite sure that they are doing a very good job.
Okay, even though I've found somewhere supposedly your quote about Mrs. Del Ponte not being a first-class prosecutor.
I did not say this, certainly not in that way. No, I never said that.
Which way?
I did not say that she was not a first-class prosecutor. She did a very good job.
Very good. What was your cooperation with her?
I think that we had a very professional contacts with. Of course, from time to time we would disagree about this or that, which is normal in the administration of a major institution. You don't want us to be all robots. I sometimes disagree, have a slight disagreement from Mr. Brammers, but still I very much appreciate the job that he's doing. I'm quite sure that Mr. Brammers has some criticism of me. It's perfectly all right. We improve institutions by criticizing each other. And as long as the criticism goes with respect to each other, with appreciation of each other's work, with appreciation of each other's difficulties, the job of the prosecutor is terribly difficult. Look, we are now dealing with crimes that have been committed so long ago. The prosecutor has to make a persuasive case. And imagine how difficult it is, still 20 years after the events, to have witnesses whose memory, whose recollection will be still strong enough, credible enough, healthy enough to persuade judges. So his job is very, very difficult. And I'm sure he's doing a very good job.
Mr. Brammertz, but let me once again...
I will not comment more on Mrs. Del Ponte. She's not here now. This is past history. Let me just conclude that aspect of your questions. I think that I have no doubt that Mrs. Del Ponte did her very best to do a very good job, and I'm sure she did it.
Okay. In some cases, especially last year, they showed huge discrepancies between decisions of a trial chamber and later appeal chamber. This left some serious criticism after that, serious doubt.
Well, first of all, look at the picture holistically, as a whole. Cases in which decisions of trial courts were reversed by appeals chamber are very rare. It so happens that in a certain period, short period of time, there were 2 of them pertaining to the ICTY, followed by on the appeal level. But this is not the sort of daily event. Those things happen quite infrequently. But my answer to that on that is a broader one. We are a court of law, and all courts of law in all countries, including Bosnia-Herzegovina, are based on a system in which one court is a trial court, and appeals from that court are submitted to a court of appeals. So you have a system in which the appeals court can read something which the appeal court never originates, never initiates. The appeals court looks at the appeal of someone. That appeal can be an appeal of the prosecutor. We have had quite a few of these. The appeal can be, as typically it is, an appeal of the accused, of the convicted person. He is now the appellant. There will be all systems of justice require, and this is universal, that another court from time to time will look at the results of the lower court, and they have a very systematic approach to what they consider are errors or things which should be revised, etc., etc. It happens from time to time, and it is, in the long run, a guarantee of justice for the prosecutor as much as for the convicted persons everywhere. Imagine that you are convicted in Bosnia-Herzegovina for something, and you feel very strongly that injustice was done to you. How would you feel if you would not be able to go to an appeals court? And would you like always to assume that going to an appeals court is a formality? It is not a formality. We are duty-bound to look at possible errors, and we have clear guidelines regarding things that we can look at. If sometimes our decisions cause pain to the victims or disappointment, I'm really, truly very sorry, but there is very little we can do about it. The Security Council gave us only one mandate, only one remit, to consider an individual case of an individual defendant, looking at the sole question whether his or her guilt has been established beyond reasonable doubt. Sometimes it is said by our critics, and I sympathize with them, that there may be decisions of trial courts, there may be decisions of appeals courts, which do not foster reconciliation. As you know, this is one of the criticisms that has been advanced with regard to particularly to one or two of the acquittals, but it can also be advanced, it is also advanced with regard to convictions. But surely we must understand that in no legal system, international or internal, domestic, national, reconciliation is a classical function of courts of law. Courts of law judge. Reconciliation, where we see that the reconciliation was successful, South Africa, Germany, This is a broader function of local and national leaderships. Unless you have, I'm not speaking now specifically of Bosnia-Herzegovina or other parts of former Yugoslavia, you need national leadership with courage. You need religious leaders with courage. You need the civil society. You need the NGOs that would take the lead in establishing patterns of reconciliation. And one of those essential elements for reconciliation is justice. And I think that we have made a tremendous contribution by creating this radiating protective umbrella of justice.
Yes, but do you have fears that your work in past 20 years would be marked by two cases or three cases, only by them?
I hope that this will not be the case. Our work has always to be taken holistically. I do believe that over time, critics of those two or three cases will have another look at them. The academic community has now, there has appeared in writings of the academic community recently, some writings which were very supportive of some of the judgments that you are mentioning. This is something that we should, on which we should not draw conclusions now. You have to see our work as a whole. It is still a work in progress. For example, one of the cases on which I was not sitting, in the case of Stanisic and Simatovic, which caused some disappointment elsewhere in some places. This case is subject to appeal. It's not even finished. It's not even finished, but look at all at the totality of our work. Yes, I am quite confident that over time the judgment of history on the quality and the fairness of our work will be very positive.
Even when I spoke to some experts, they said, yes, it's true, but such a discrepancy shows that there is something wrong. 27 years, then acquitted. 24 years, then acquitted. There is something wrong.
I don't subscribe to that view. It is characteristic of decisions of appeal courts that they reverse things. And again, please bear in mind the fact that those cases have been so very rare. So look at the totality of the work, and look, I accept and I appreciate outside criticism, but how many people outside have read every single word of the briefs the way that appeals judges do? Sometimes you see a criticism comes out within hours of the appearance of an appeals judgment which is disliked by someone, a critical reaction, and I ask myself, well, this person who wrote that must be a terribly quick reader if he has managed already to really read, to consider, to reflect on all the briefs, on all the judgments of relevance, on all the decisions of relevance which has preceded it. I will tell you this. The failure of international justice will be if judges will reach their decisions not based on law, but based on politics, based on a broader agenda, which they do not have, because they will not fulfill the discrete, the sacred role of judges. Now, we are human beings. I am not suggesting that we are always infallible, but we are, I can tell you one thing, we are independent, we are competent, we are professional, and we are very committed to doing the best job we can.
Did you make your decisions in, so you were presiding appeals chambers in those two cases, did you make decisions under the pressure of any kind?
Of course.
There are some people who would say this could lead to a rule, not an exception.
I saw those criticisms. Again, I am sad about them. I do not rejoice in. We are independent judges. We never listen to pressure. And actually, I must tell you, nobody is trying to pressure us. We are anybody with any sense would know that to try to influence a judge is something which is such an anathema to modern concepts of judicial independence, that the person who would try to influence a judge would be clearly and immediately rebuked.
How?
By being by saying go out, by being thrown out of the room. We would never listen to attempts to influence us. But I think that we should not assume that political leaders are stupid enough to try.
So what are your connections with the US government, Israeli government?
Israeli government, I left Israel a very long time ago. I gave up Israeli nationality more than 30 years ago. I have no connections with Israeli government whatsoever. So let's put this to rest. People who have written stories without any foundations about my being inclined to listen to theoretical Israeli views, and they've never tried to approach me. They never will. Forget that in my previous reincarnation, I wrote a famous opinion, which is very well known after the 6 Days War, in which I stated explicitly that settlements on the West Bank violate the Fourth Geneva Convention. Can you imagine that a person who as a young man had the courage to give such an opinion would now be listening to pressure from anybody or from influence from anybody? Now, as regards the United States, I am an American citizen. I feel very warm about my country. My country welcomed me when I immigrated to it. My country gave me great possibilities in academia. I became, soon after moving to the United States, a professor at NYU. My contacts with the American government are the same contacts I have with all the governments of the United Nations. As president of the tribunal, I go to the Security Council. In fact, I'll be going this weekend. Every 6 months, I have to report to the Security Council. I meet typically, or try to meet, with every single member of the Security Council, including the so-called permanent members of the Security Council. But I meet the Chinese ambassador as frequently as I meet the Russian ambassador as frequently as I meet anybody from the US.
Is anyone trying to bring his own agenda on the work of the ICTY?
From nations?
Yes.
No. States would, for example, states would say to us, well, we think you should go faster. We think that you may be too costly from time to time. But their agenda, there cannot be such a thing. Speaking to the Security Council in the completion strategy, time after time, I told in open public meetings of the Security Council that, of course, we are aware of the cost. We are aware of the desire of the community, international community, that we should come closer to conclusion of our work. But I said, we will never cut corners on justice. We will never cut corners of fairness. And if what you are telling us would bring us to a clash between our judicial obligations and what you are asking us to do, for example, to speed up, the choice for us is very clear. We go by due process.
When is the time for drawing the curtain, and what happens after?
Okay, that's a very, very good question. As you know, trials are still continuing, especially of a number of people, very important people, accused, who have been arrested relatively late. That means Mladic, that means Hadic, and even Karadzic was arrested later than some. Now, most of the appeals court of the ICTY will be finished in the course, and ICTR in fact, will be finished in the course of 2014. The trials of Mr. Hadjic, Mr. Mladic, Mladic, Hadjic, and Karadzic will run into 2015, and one case, that of Mr. Mladic, will run into 2016. The appeal of the Croatian leaders, the case of Perlic, will run even later into 2017. There's nothing that we can do about it. It's a very complex case. It's a case in which the judgment of the trial court runs into more than 2,000 pages, just the obligation of translation. But we are moving rapidly, and soon the work of the ICTY will be greatly reduced as a result of these developments. But those trials, those appeals have to be treated correctly and not under any pressure of time, because we do not want pressure of time or any pressure to contaminate the purity of judicial proceedings. But my object now, as you may know, I am, in addition to being president of the ICTY, I am also president of the newly established tribunal, the mechanism. Now, the mechanism, according to the timetable established by the United Nations Security Council, will have the mechanism, the MICT, will have jurisdiction over the appeals of, if any, of Mr. Mladic, Mr. Karadzic, Mr. Hadjic, and Mr. Seychelles.
Mr. Meron, thank you very much for your time.
Thank you very much for coming.
Thank you.